I don't know. We'll see.
I don't took third one. I thought I got so bored. I'm not going to take. It's anyway happening to people. People are getting infected after three doses. There's no point. Now two is sufficient.
Yeah.
Good afternoon, Anuj.
Anthony. Hello, Dr. Rao.
Yes, hello.
Hi, Dr. Anand.
Hi.
Hi.
Dr. Harita is joining us. She is actually on the way. She's traveling. She'll join us online again.
Hey, Anuj. Just FYI, I think if we can keep it within about an hour and a half from now, in terms of the total time, that would be good, because I actually have a meeting to head off to afterwards. So yeah,
No problem.
about 90 minutes. Thank you.
That's what I think. That 45 minutes to 60. That was a perfect frame.
Perfect.
If it is exciting, I'll club and give a common one, and then after that we'll end. But I'll request you and Chris to visit India soon, anytime. Once I'll give you a green signal once this COVID ends, in a month or two.
Awesome. I'd love to go. I've never actually been. It's very, very high on the list of my places to go. Just I've never had the opportunity to go there in the past. But
then
definitely one day.
Definitely. And you should come once.
Hi, Dr. Harita.
Hello, how are you?
Very, very well, thank you. How are you doing?
Yeah, very good. I'm fine.
Good.
Anthony and Chris, our registrar sir, has joined in.
Hello, sir.
Hello.
Good afternoon.
Yes, good afternoon. Students are facing some technical issue in joining, but they are trying to join.
Should I start it? They'll join in the middle. In any case, I have to do the introduction, so I think I'll start off. I think by that time they'll join also. Will that work?
Yeah, that can work, ma'am.
A very good afternoon to all. I, on behalf of our Honorable Vice Chancellor, Professor Dilip OK, and Registrar Dr. Anil Verith, welcome you all. Due to some exigencies, our Vice Chancellor could not be present with us, but he has ensured that all the arrangements to conduct the colloquium are at place. I consider it to be my privilege to welcome my esteemed guests, Mr. Anthony Clay Nichols, Counsel Forte Law LLC Singapore, Mr. Christopher Bloch, Senior Associate Square Pattern Blocks Singapore, and Mr. Anuj Singh, Advocate, Supreme Court of India, Standing Counsel, State Government University. I request the Registrar of the University, Professor Dr. Anil Verith, to please say a few words.
Thank you, Dr. Garma.
Hello, sir.
Yeah. The resource persons, Mr. Anuj Singh, then Anthony Nicholas, and Mr. Christopher, Dr. Anand Raut,
Dr. Harita Bengali, our other faculties, staff, and the participants who have joined this platform today. Greetings to you on behalf of the Maharashtra National Law University family, on behalf of the Vice Chancellor, the faculty, and members of the staff. So at the outset, I would like to congratulate the Center for Postgraduate Legal Studies and the Center for Advanced Legal Studies and Research for organizing such a program, which is very, very important and vital at this point of time. Because it is needless to say that the quality of governance in a country to a great extent is reflected through the system of justice dispensation it has. A robust legal dispensation, legal justice dispensation system is one of the prerequisites of development, and the alternative dispute resolution mechanisms, including the mediation, plays a very important role. Of course, we are aware that Singapore has gone much ahead in arbitration and other alternative dispute resolution mechanisms. But India, though it may take some time to come up as an institutionalized mechanism, but in India also, alternative dispute resolution through negotiations and mediations have been in place from time immemorial. But maybe because of the colonial legacy which we are carrying in the legal system, and also due to the passage of time, somehow India as a legal system has been more inclined towards adversarial system. But now, by and large, the world has realized that adversarial system cannot give you a a satisfactory solution to your legal disputes, and therefore it is time for us to look forward to other means of dispute resolution. So this webinar, I'm sure that though it's a humble and a small initiative, it will go a long way in future if the stakeholders who are joined here all partner together and carry forward the vision forward. So I do not take much time. I would like to extend my hearty congratulations for organizing this program, and I wish you all the best and success in this. Thank you very much.
Thank you so much, sir, for your encouragement. I would like to briefly introduce about the university and its achievements over the last 7 years. Your Maharashtra National Law University, Mumbai, established under the Maharashtra National Law University Act 2014 on 20th March 2014, is one of the premier national law universities in India. The Act envisaged to establish National Law University in Maharashtra to impart advanced legal education and promote a society-oriented research in legal studies for the advancement of the societal life of the people in the country. The prime goal of the university is to disseminate advanced legal knowledge and processes of law against the students and impart in them the skills of advocacy, legal services, law reforms, and make them aware and capable to utilize these instruments for social transformation and development. The university has actually not looked behind since its inception, and it has witnessed unprecedented growth story since Professor Dr. Dilip Uke has headed it, and be it offering of various bachelor's and master's program, establishing research centers, organizing conferences, workshops, seminar, crash courses, training programs, research projects, national and international collaborations, and the list goes on. So this was supported by vast network resources, administrative legal practice experience of our registrar, Professor Dr. Anil Vairith. In the recent years, the university has taken long strides in areas of research and has established numerous research centers in the area of clinical legal education, your criminal justice, maritime law and research, intellectual property, your tax law, arbitration, mediation, and information technology. MNLU has also been granted Department for Promotion of Industries and International Trade, DPIIT, Ministry of Commerce and Industry, Government of India's IPR chair. MNLU Mumbai also established the Center for Maritime Law and Research with the support of the Directorate General of Shipping, Government of India. Recently, the university also established Justice M.L. Panse's chair in environmental law. The university also has taken several research projects. The university is offering BA LLB honors 5 years integrated program, 1 year LLM program in corporate and commercial laws, maritime law and constitutional law, LLM professional, LLM investment and securities law, association with National Institutes of Security Markets, SIBI, MA mediation and conflict resolution, your postgraduate diploma programs, among others. University is also planning to add more specializations for the academic year. The university also hosts several programs in association with foreign universities. I sincerely believe that this colloquium shall provide a platform for the new aspirants who are looking for international opportunities and they would become familiarized with the various challenges ahead. Without any further ado, I would like to invite Mr. Anuj Singh to talk about, uh, domestic arbitration to please commence the colloquium. Thank you. Anuj, you can take it forward.
Yeah. Thank you so much, Dr. Pal. Hello, everyone, and thank you for joining us in this colloquium. I'm Anuj Singh. As Dr. Pal has mentioned, I am a lawyer primarily practicing in Supreme Court and a standing counsel for the state government, multiple state government undertakings. So today we have gathered to discuss key issues and approaches and opportunities in dispute resolution regime vis-a-vis Singapore and India. So arbitration in India is always considered as a part of alternative dispute resolution mechanism, and which I find as a misnomer, and Mr. Anthony and Chris will agree to this fact that arbitration is one of the most sought form of dispute resolution mechanism for all form of commercial disputes. And it's always a first court of call, and that's why intentionally we named the seminar as under the bracket of dispute resolution rather than alternative dispute resolution. Arbitration has been evolving in India past 5 years, and recently two major amendments of 2015 and 2019 has been a major breakthrough, and few Supreme Court judgments that has overhauled the arbitration regime. But constantly there has been a feedback which comes from end users, which are which are clients, industry people, or even the law student, that there still remains some confusion on arbitration in India about the procedural aspect or the legal situation because of the constant intervention of Supreme Court or High Court, or even due to non-clarity within the statute. So what I've done is I've shortlisted few key issues that are needed to be addressed in present Indian arbitration scenario. The legal framework, I'll be very brief in that. The legal framework, as you all know, the Arbitration Act of 1996 in India prevails, and which has been recently amended by 2019 Amendment Act as well as 2015 Amendment Act, which has brought a large number of provisions in consonance with the model of UNCITRAL. Part 1 of Arbitration Act applies to domestic arbitration in India, and the Part 2 relates to those certain foreign awards which are provided under the given under the New York Convention or the 1923 Geneva Convention. But there has been some few exceptions that Part 1 of the Act, which is exclusively for domestic arbitration, there are few provisions such as Section 9, which is the interim measure, which is one of the most, I would say, one of the most important section and hotly contested matters in every in High Court or Supreme Court across India. Section 9, Section 27, which is another one of the most important section about the assistance of court in taking evidence, or Section 37, subsection 3, which bars any such second appeal to Supreme Court except to Supreme Court. So these are a few provisions which are made applicable to international commercial arbitration as well from Part 1, which refers to domestic arbitration. So three issues which I have shortlisted. First is arbitration agreement. As we all know, arbitration is a feature of contract. The process starts with a arbitration clause within a contract. The issue as a practitioner of court, I would say the issue which we regularly come across is the carelessly drafted arbitration clause, which prolongs legal proceedings. And all commercial contracts are of varying in nature. Few are complex, few are simple, few depends on the nature of industry, the size of industry, the monetary value involved in the transaction, and the kind of contracts like shareholder agreements or vendor agreements. But the dispute resolution clause depends on what kind of contract we are entering into. There cannot be a straight jacket formula that see this is the ideal arbitration clause. There cannot be a fixed straight jacket formula for every arbitration clause. So, but the sole intention of arbitration and the objective behind the whole arbitration process is to save time and money. And the best case scenario, because the law students are listening to this, the best arbitration clause should not be open to multiple interpretation, because once you open the clause for multiple interpretation, it can lead to a long list of litigation varying person to person and court to court. So let me give an example, and I am giving a practical example which I've seen within court, that people have put even number of arbitrator within the contract, which is specifically not which has been barred by the Recent Amendment Act, that it has to be in even number, odd number. People have put even number of arbitrator within the arbitral tribunal, or a 3-member panel of arbitrator in a small value contract. So which again defeats the objective of cost and time, because anyway the 3-member arbitral tribunal is going to take a lot of cost in comparison to what you're going to get in as an outcome. Or not explicitly mentioning what all issues you will be referring to for the arbitration. There are contracts which we find within court which says that we are going to undertake a institutional arbitration as a preferred method for arbitration, but they fail to inform which particular institution they want to proceed with. And that again lead to another set of dispute that because of the divergence of opinion within the parties. So courts are flooded with these thousands of cases which are only involved in interpretation of such clause. So therefore, while drafting such commercial contract, there need to be very clear that what type of contract we are entering into, what kind of tribunal we are looking for, what seat we are looking for, seat I will be discussing in the latter part, and what rules we want to get it governed, and many more. So those are the factors which we need to focus upon while drafting our arbitration agreement, so that there's no litigation involved once a dispute arises. I'll give you I recently read a media report that LCIA India office shut, I think 2-3 years before, and still there are multiple arbitration agreements which are referring LCIA India office as a institution for their arbitration. So these things which needs to be taken care by the lawyers or the firms which are dealing in the arbitration agreement, and generally it is referred as arbitration because the clients are least interested, at least in domestic arbitration scenario, in the dispute resolution clause. So that's why it's generally referred as 4 AM or champagne clause. But let me tell you, it's one of the most important clause which matters the most when a dispute arises. And coming to the second part, which is one of the most important part of the arbitration, domestic arbitration specifically, the seat and venue debate. So the seat of arbitration is ultimately the center of gravitation of your arbitration clause. The 1996, which is present act, the predecessor of this act, 1940 Act, it does not talk at all about the seat of arbitration as a concept. It did not find any place there. But the code slowly started, because within the domestic arbitration, there's no issue about the conflict of laws. The conflict comes when there's an international parties is involved, or the seat has been made outside India. So there has been a constant tussle, a long tussle since 1990, since 2000, about the seat and venue of an arbitration clause and what exactly that seat and arbitration would mean. And I'll take 30 seconds to quote a very important judgment, which to tell a para which explains the whole scenario. which is a constitution bench judgment of law student must be knowing, a Balco judgment. It says that the legislature has intentionally given jurisdiction to two courts, that is the court which would have jurisdiction where the cause of action is located and the court where the arbitration takes place. This was necessary as on many occasions the agreement may provide for a seat of arbitration as a place which would be neutral to both the parties. Therefore, the court where the arbitration takes place would be required to exercise supervisory power control over the arbitral process. And in such circumstances, both the court would have jurisdiction, that is the court within whose jurisdiction the subject matter of suit is situated, and the court within the jurisdiction of which dispute resolution, that is the arbitration, is located. So this the constitution bench judgment gave the concurrent jurisdiction to arbitral proceeding to firstly the court possessing the subject matter where the cause of action arises, second to the court where the place or the seat of arbitration is designated. Unfortunately, there is a huge lack of clarity when it comes to the statute in India. So within the statute, there is no single term called seat. Actually, it refers to the term place. So which creates another set of confusion within the statute. But recently, Justice Winter Nariman in BG Soma case, he has settled the whole dispute of seat versus venue, and which is what exactly going to be the governing law of the arbitration. In a single line, he has said, once the seat of arbitration is designated, it is akin to an exclusive jurisdiction clause. So this settles the whole debate that once you have fixed the seat of arbitration, it exclusively defines the jurisdiction under which the rules of the arbitration will fall. Moving on to the another so it's a judge-made law actually, and it has been continuously been evolving through.
For which member you are making?
There has been no particularly statute which speaks on seats or place or seats and venue of arbitration. So the legislative amendment has to be brought in India so that the confusion and this clarity needs to end. Clarity needs to come and confusion needs to end. The last very important issue which I'll be talking about within a domestic arbitration practice is the appointment of arbitrator. So we have got recent amendment that fixes the timeline for the arbitration, but the appointment for arbitral tribunal is another arduous task. There has been no clarity and just confusion that results in delay. So the 2015 Amendment Act grants the liberty to the party to appoint an arbitrator mutually, and they are free to determine even the number of arbitrators, and it shall not be an even number. But whenever a party fails to do so, the arbitral tribunal consists of a sole arbitrator, or they approach a high court, which in turn appoints the appoints the arbitrator. Issue in India is that even today party believes in ad hoc arbitration, hence the responsibility of appointing an arbitrator is always in the hands of high court, and whenever this dispute arises with respect to a mutual agreement on a particular set of arbitrator, the Section 11 petition is filed, which almost takes 6 months to 2 years to get the arbitrator appointed. So this huge delay is causing not just causing the economic harm, as well as it is defeating the complete purpose of arbitration only, because if the arbitrator is getting appointed in 2 years, then the whole purpose is lost. So the legislative amendment as well as the judges of High Court and Supreme Court needs to take care of this particular part, that the arbitrator appointment needs to be done expeditiously, because it loses the whole purpose. And then recently the Supreme Court came with a very strict approach, and they concluded the invalidity of a unilateral appointment of sole arbitrator, because it was consistently, it was happening that one party was getting a edge to appoint a sole arbitrator of his own choice without disclosing any interest or impartiality. There has been a case where recently in a Supreme Court where a employee was appointed as arbitrator without disclosing the details. And later on, when the party got to know that about the arbitrator, the award was cancelled because it has a huge interest bias in that. So this practice has been constantly been there within the arbitral tribunal, and recently the 2019 Amendment Act has omitted this practice. They have asked the institutional arbitration, the arbitral institution to appoint the arbitrator. Unfortunately, since last 3 years, that particular amendment has not been notified. So we expect that that particular amendment is going to be notified very soon, and so that this old regime can be replaced, and this appointment of arbitrator should not be a tussle in a high court or a Supreme Court, rather than it should be between the parties and mutually agreed, so that the commercial interest can be taken care of. So, because considering the time limit, I'm restricting my domestic arbitration part to these 3 points. What we have tried to do, we have in this webinar, we sought for few responses from the student as well about the query, and with respect to the international commercial arbitration or arbitration in Singapore. And so we are now we are going to begin with a Q&A. We will be doing a Q&A format, and with Mr. Anthony and Mr. Chris. And because these topics on its own are so big that it can require a webinar of its own. So, but we have time constraints, so we'll be try to do justice with each topic, and whatever questions where the students have raised before us, and try to accommodate whatever queries and the question put up by the students. And so, hello, Mr. Chris, can you hear me? And Mr. Anthony?
Yes.
And thank you so much. Let me tell all the students, Mr. Chris and Mr. Anthony has tremendous experience with when it comes to the arbitration, international commercial arbitration, and they have been both have been a regular practitioner of arbitration and very rich on-ground experience, which is going to be an asset for everyone today. And let's begin with some practical insights from Mr. Anthony and Chris. Mr. Chris, Anthony, you are free to answer anytime as per your convenience. You can decide, and there's no time limit. You can let you answer freely. So it's beginning with a very fundamental question. What is the exact distinction between the ad hoc arbitration and institutional arbitration, and are there some areas of arbitration which are overlapping in these two concepts?
Sure. I mean, I guess Anthony, you can jump in and add any of your insights as I go through this. But I think one of the key distinctions that you have to understand between institutional arbitration and ad hoc arbitration is that ad hoc arbitration really has no oversight apart from the court and the tribunal. In any arbitration, whether it's institutional or ad hoc, the parties are the masters of the procedure. As you rightly mentioned in your opening remarks about domestic arbitration, it's a creature of contract. So the procedure that the parties choose is the procedure that the parties get. And that is the same regardless of whether it's institutional or ad hoc. But in an institutional arbitration, you have an additional layer of administration and oversight that is aimed at efficiency. And that is really the key to institutional arbitration. Ad hoc arbitration, when you appoint an arbitrator or a tribunal of 3 arbitrators, they essentially dictate the terms of their appointment. They set their hourly rates. That then obviously affects the cost of the arbitration. On the other hand, certain institutions like the SIAC or the ICC have what's known as an ad valorem fee scale, where tribunals are paid based on a set schedule of fees. So for these complex, large, high-value disputes, the time that these arbitrators put into this case will actually be, and the payment for that time will be dictated by that schedule of fees. So in some cases, ad hoc arbitration, there can be kind of a runaway of costs with long drawn out cases that go on for years, and the arbitrators are charging at an hourly rate. The efficiency that's brought by a guidance from the tribunal, from the institution on the tribunal's fees can help kind of get a hold of that cost. And the other thing, as far as oversight and administration is concerned, is that institutions have kind of decision-making power on certain preliminary matters that occur before the appointment of a tribunal. For example, the SIAC, if there's an objection to jurisdiction, that can be made even before the constitution of a tribunal. It's decided by the SIAC court. It's decided on a very quick and expeditious basis, whether there's a prima facie arbitration agreement binding the parties. And it could potentially knock out a case within a matter of days, as opposed to in let's say, an ad hoc arbitration where it might have to go all the way through the process with the tribunal and potentially go to court. There are decisions on expedited procedure, early joinder, various things like that are actually taken by the institution. So the key here, that you can keep going on and on about examples of administration, but the key is that extra layer of oversight. Anthony, I don't know if you want to add anything on that.
Thanks, Chris. I think that's a very comprehensive introduction to the issue. And of course, I agree with all the things you've said. I would say, Anuj, that the question that you asked is, what is the difference between institutional and ad hoc arbitration? And then secondly, what are the similarities between the two of them? Okay. Generally speaking, by the time that you get into the meat of the arbitration, in other words, once the arbitration is up and running, they're actually generally quite similar, in the sense that, as Chris was mentioning, the parties, through their counsel, will be the ultimate masters of the arbitration. The real issue is, how do you get to the stage where the arbitration is up and running? Now, for an institutional arbitration, as Chris was saying, you have this layer of infrastructure, which makes sure that the arbitration can get off the ground. And the reason why that's so important is because quite often in an ad hoc arbitration, you don't have this underlying infrastructure, and it leaves lots of gaps that can be potentially exploited by a party if they want to derail the arbitration. Now, one area is with regards to fees. If in an institutional arbitration, it's the institution which will be the one pushing the parties to give them an initial deposits. And those deposits will then go to paying the arbitrators as the case goes on. The difficulty in an ad hoc arbitration is that there's nobody asking for those fees. So you have the arbitrators themselves saying, hey guys, please pay us the money up front. And it creates a very strange dynamic in the sense that if a party is not willing to pay those arbitration fees to the arbitrators, you have to essentially do it to the arbitrator's face. You have to say, no, I'm not going to pay you. And everybody wants to get paid, right? So it creates again a very, very unusual dynamic, which, for example, in an institutional arbitration doesn't exist. In other words, if you're a party in an institutional arbitration, you can use the fact that you don't want to pay deposits as a tactic to not proceed. So again, generally speaking, when the arbitration is up and running, they're actually quite similar. But it's really at the beginning stages where there are lots and lots of pitfalls, and there are lots of ways that parties can tactically or otherwise derail the arbitration. That's where the institution steps in and says, no, look, we're not going to do it that way. We're going to do it this way, and we're going to keep things moving.
I think one other thing to just add, and that's actually kind of dovetails from that, is that every institution has its own process and its own kind of level of administration. So when you're choosing an institution, you have to be aware of what their kind of case administration and processes look like. Anthony and I do a lot of SIAC arbitration, being based in Singapore. An SIAC arbitration is very different than an LCIA or an ICDR arbitration. The administration looks different. Let's say another one that's very common in this region is the Singapore Chamber of Maritime Arbitration, which for the most part is just an ad hoc arbitration with a fund holder. That's pretty much what it looks like. So like Anthony said, there's a the differences once the case gets up and running are very very minimal between the institutional ad hoc arbitration, but you also have to be aware of how each institution actually differs. For a small value shipping case, SIAC might not be the place you want to go. It might be LMAA, which is the London Maritime Chambers, or the SCMA, or a very specific industry oriented institution. Whereas other cases, the more high value, complex energy or construction or infrastructure may be better off at an SIAC or an ICC. So it adds another layer of complexity. It's not enough to just say ad hoc and institutional arbitration are different. You have to understand that institutional arbitration is also different depending on the institution that you want to go before.
I think that's a hugely important point, actually, which Chris just mentioned, that there's a very big distinction between these different institutions. So again, as Anuj, as you were mentioning at the beginning, it depends on who your client is and what they're trying to achieve. So if you have a very small arbitration, sometimes it's good to have this very simple ad hoc procedure where the parties jointly nominate one person. If you represent, for example, an Indonesian party, it's maybe preferable to have a BANI arbitration. So BANI is the domestic institution in Indonesia. Now, if you're representing the domestic party, the Indonesian party, it actually sometimes makes more sense to include that BANI arbitration agreement rather than an ICC arbitration agreement, which is more international in nature. Because again, if you're representing the Indonesian party against, let's say, a Chinese party or a French party, naturally they're going to want something which is more similar to what they're used to, and which is therefore more difficult for the other side. So again, it comes down to the fundamental question at the beginning of who do you represent and what are you trying to achieve. So when you have that in mind, all of the subsequent analysis will change accordingly.
Before we move to a second issue, I have a small, you can give a brief comment that our general criticism comes that these institutions have unrealistic time frames. They don't care about what size of matters are coming, but there are unrealistic time frames within these institutions. So do you agree with this criticism, or what's your take on this?
I mean, I think it really depends. I hate to say it depends as an answer, but the complexity of a case factually, legally, procedurally has a lot to say about how long it's going to take. What I do not like is hard and fast time limits, saying that you have to complete the case within 12 months. Or you have to complete the case. You do not know at the start of a case how things may develop, and the parties may actually benefit from a longer arbitration. Imagine a situation where, after the first round of document production, it shows that there's actually a need for further document requests, and that might help narrow down the issues, the factual issues in dispute. Document production can be a very long piece of an arbitration, spanning several months. If you have to go through potentially a second round that might benefit the parties and the quality of the judgment, if you're restricted by a time frame, that would not be beneficial. So you have time limits in place, like at SIAC, for example, the expedited procedure time frame is 6 months. Well, that's great, and for the most part, cases that proceed under the SIAC's expedited procedure are finished within 6 months. However, the registrar does have the authority to remove it from the expedited track if certain things develop and circumstances change and make it unlikely or impossible for a 6-month conclusion. So it's really flexibility that needs to be kind of the focus, and make sure that the institution or the tribunal or whoever has the power to be flexible with that.
Again, I would largely agree with Chris. There is a slight area where I would be a bit more in favor of these harder time limits. So one of the reasons why parties choose international arbitration as opposed to going to domestic litigation is because quite often parties come from jurisdictions where the national courts are slow. In the European Union, for example, the Italian courts are quite well known for being very slow. So if you're a party that wants to purposely choose slow court proceedings, you'll sometimes put the Italian courts, a jurisdiction agreement for the Italian courts. So bearing in mind that there is this risk of slow proceedings in the national courts, people sometimes choose arbitration, rightly or wrongly, because they think it will be faster. Now, I agree with Chris in the sense that you shouldn't rush all cases, regardless of the types of issues and the complexities involved. Though I think there is something to be said about having general time limits in place as sort of like the default or as the de facto position. In India, for example, I believe the 2015 amendments, they actually introduced a time limit for the awards, right? I think of 12 months from the appointment of the tribunal.
Yes.
Yeah, and it's the same in other countries and under other arbitral rules. The SIC, as Chris was saying, there are procedures whereby if you have a small value award dispute, you can go under a particular procedure, the expedited procedure, and you have very short truncated timelines. That even for more complex disputes, as in ICC proceedings, again you have a general timeline in place. Now, as a matter of reality, the relevant registrar can extend that timeline, but I think it is good nonetheless to have it as a benchmark in the parties' minds that, generally speaking, unless you're dealing with a really complex or exceptional case which requires this extension, you have this general benchmark to aim for. So you don't end up having like 32 merits hearings, which span like 4 years, 5 years for a fairly simple case. And again, these are real life examples.
I completely agree with that. And actually, one of the things that institutions have done to help promote the efficient resolution of cases is they link the tribunal's remuneration and have the power to actually reduce the tribunal's remuneration if they lose control of the time and efficiency. So for SIAC, I can tell you firsthand, because I worked there for 3.5 years, after every single case, the secretariat would do a forensic review of the case. They would look at the efficiencies and the inefficiencies of both the SIAC's actions and the tribunal's actions, and they would allocate and apportion the costs based on that. And the tribunal would be very well aware that they have not received the full amount of the, let's say, the maximum fee cap. And they would be told that it's in part due to the inefficiencies and maybe a slow award, or allowing a recalcitrant party to slow down the proceedings. So there are obligations under the ICC rules, there are obligations under the SIAC rules for the tribunal to proceed in an economic and efficient basis. And that just goes to that whole heart of the matter of trying to push it. But you have the reality that sometimes if both parties agree to hold a case in abeyance for 6 months, 12 months, 18 months, and I've seen that. I had a case that was in abeyance the entire 3.5 years that I was at SIAC. And the parties continuously said, we have agreed to extend for another 3 months. And every 3 months, I could put it on clockwork on my Outlook calendar that I would get an email from one of the parties saying that they would agree to another 3-month extension. And if the parties agree to that, there's very little the tribunal can do, because like we said, and this is something that it's just a kind of a mantra in arbitration, is that arbitration is the procedure that the parties want. And actually, Anthony and I, at the start of our careers, actually worked in the same office. And the first case I ever worked on was a case where the tribunal was working on their 16th tranche of hearing. And when I left, they were on about their 26th tranche of hearing. And the person that picked up that file after I left, I spoke to about 2 years later, and the case was still proceeding. And they were on about the 40th tranche of hearings. And they would take one witness and they would spend 5 trips to the jurisdiction just hearing cross-examination of one single witness. And that's the type of stuff that we're now trying really hard to avoid in international arbitration. But every once in a while it does happen.
Actually, Chris, that was exactly the case I was thinking of when I mentioned the multiple hearings. And again, this really feeds into, what are the different incentives involved when you have ad hoc versus institutional arbitration? Imagine you're a retired Supreme Court judge, and you get this lovely, $1, $2, $3, $400 million dispute, and you'd say to the parties, okay, I'm going to charge you on an hourly basis, and of course, because you're the arbitrator, they say, sure, fantastic, right? Who is there to stop you from having 26 hearings? And at each of these hearings, you're just recording your time, and you're just seeing the numbers click, the timer clicking, the numbers going up. And again, who's going to say, sorry, sir, I think we've had too many hearings? They're not, because the parties aren't going to do this, because they are the ones who have appointed you to be the arbitrator. And again, that's where these arbitral institutions come in, because they stop this sort of behavior by creating this disincentive for the tribunal to extend the proceedings. So I think it doesn't happen all the time with ad hoc arbitrations. Usually the tribunals are a little bit more cautious of this. But again, sometimes when you have a huge case, then
I think we were discussing that day the remark by Chief Justice of India that how $1 lakh fees was taken as arbitration fees apart from the reading fee. So the Chief Justice of India has to step in and make a remark that we need to stop arbitration in India if this continues. So this high cost of arbitration is a big bottleneck in India specifically.
That's a very interesting point, actually. When you specifically fix fees at whatever the number is, regardless of the complexity of the case. And again, Chris and I have another former colleague who worked with us at the same law firm at the beginning of our careers. And I remember that he had a case where he was sitting as arbitrator, and the amount in dispute was quite small. It was an SIAC case. It was a quite small amount, but it was a very complex construction case. And he was tearing his hair out because he was working on this case for about 18 months and got paid about, I don't know, $10,000 for it. So and that's the amount that he would normally make in like a week if he was working on one of his normal cases. So again, whenever you have fixed fees, it's a little bit, it cuts both ways. But generally speaking, it stops this fee inflation by tribunals on ad hoc arbitrations.
So with this rising global transactions, cross-border transactions, there's a concept of third-party funding in international commercial arbitration. So you both have been into the international commercial arbitration for such a long duration. In India, the third-party funding has been a developing concept, and there's been a resistance constantly toward the third-party funding. There's been a few Supreme Court remarks on that, and there is not a clear framework with respect to third-party funding. So I wanted to know what exactly third-party funding in international commercial arbitration is, and is there any rules made by institutions like SIAC on the same?
Sure. I mean, it's a very hot topic, and we could have a 2-hour conversation just about third-party funding. So I'll kind of keep it to the high points. For those of you who aren't familiar with third-party funding, it's essentially a tool to bring in a third party that has no interest in the outcome of the dispute, to fund the legal fees and the costs of the arbitration, to essentially allow a party to bring a case without the risk of the costs associated. And then what they do is they exchange that funding for a piece of the award. If the party loses, then the funder, it's considered a non-recourse basis. The funder gets nothing, and they are still on the hook for the funds. But if the party wins, then that funder essentially has terms of funding, a funding arrangement, a funding agreement with the party, that they get their costs that they had paid back plus a percentage of your win, your award that's recovered. Now, this is something that has been illegal in several jurisdictions for a long time, Singapore and Hong Kong being two of the famous international arbitration centers where it was illegal based on the English torts of maintenance and champerty. And those were in place to disincentivize the promotion of litigation. They did not want third parties, uninterested parties, to promote other parties to file lawsuits. So it was illegal to do so. But in 2017, Singapore, came to notoriety for taking the step of finally removing that obstacle. Singapore did it very carefully, and after a lot of consideration, investigation, and draft structures that they reviewed for several years. And I think that is very important for any jurisdiction that is going to introduce the concept of third-party funding into their arbitration structure. It has very lofty and weighty goals or aims of access to justice. But there are also obstacles like conflict of interest issues, and concerns about involving third parties in litigation. So what Singapore did was they spent several years with the Ministry of Law, the LRSA, which for right now I'm forgetting what the acronym stands for, but it's the essentially body that governs solicitors. The SIC was heavily involved with the discussions, and also the informal arbitration bar that exists in Singapore. And they essentially structured it in a way which would only allow for third-party funding to be taken up in international arbitration. It was not allowed, still to this day, not allowed in domestic litigation or domestic arbitration, except for insolvency matters. And what they did was they created certain thresholds to make sure that funders were liquid and they could actually fund these types of cases, and that they wouldn't then just go bankrupt and leave a winning party on the hook for the costs that they couldn't pay. They asked SIAC to put in place certain structures within the institution. So a practice note was released back in March 2017, which deals with certain aspects of the arbitrator's powers to force a party to disclose a funding agreement, and to essentially bring the funding arrangement out into the open, and also conflicts of interest questions like disclosure obligations, whether a arbitrator has a financial interest in potentially a funder, and also dealing with how a tribunal can consider the existence of a funding arrangement in cost allocation, giving them the right to issue an award that actually binds a non-party. And that's something that's very strange in international arbitration. You generally cannot bind a non-party to an award, but in a funding situation, that's exactly what happens. So you can have them, make security for costs orders, things like that, which would otherwise not be available. So, I mean, that's probably an overly in-depth discussion of third-party funding, but the aims have always been to bring about access to justice for those parties that couldn't afford potentially to fight. It's this David and Goliath scenario where you don't want the situation as a country. As a justice system, you don't want a company not to be able to, or individual not to be able to bring a claim purely because they are outmatched financially by the other side. But that's not to say that's the only way that it's used. And in practice, it's used even by some multinationals to essentially take the litigation war chest off of their annual budgets and place it somewhere else. And so you might have, I'm just going to pull a name out of the hat, but like you might have a British Petroleum, a BP, who may fund some cases. Could they fund that on their own? I'm sure they could. But there may be some reason why they want to remove that. So it's not limited to just the small investor or the small company, but can be used by anyone.
Any remarks?
I think, yeah, I think Chris has given a very, very comprehensive and wide sort of analysis on third-party funding. So I'll just add in, a couple of perhaps interesting details here and there. So it's ironic that, as Chris was mentioning, nowadays third-party funding comes up sometimes in the context of access to justice, meaning how do you make it fairer for the party with less funds to nonetheless preserve its rights and fight for its rights. And that's where these funders come in. But the reason why third-party funding was historically banned, and we're talking centuries ago, is because you would have very wealthy landowners who would use their wealth, their power, their influence to intervene in a court proceeding between, let's say, two peasants. And the way this would happen is that the wealthy landowner would give money and resources to one of these two peasants to fight against the other peasant. Now let's say the dispute was worth £10. The amount of money was worth £10, and the wealthy landowner would say to peasant number one, I'll give you this money, and then we'll fight this case, and then I'll take £4, you take £6, or I'll take 6, you take 4. And because of the absolute inequality of arms that would be created by this wealthy landowner supporting the first peasant, the second peasant just couldn't fight. In other words, the landowner would hire these expensive lawyers, and the other peasant, he's just a peasant, right? So they perverted the course of justice by having this external third party, that the wealthy landowner, come in. And so for many hundreds of years, that was this practice of a third party coming in, what was banned as a tort and as a crime, but particularly to stop this sort of thing happening. But as we've moved into we're in the 21st century now, obviously financing and the way that companies and individuals run their personal and corporate operations, you have more complex financial instruments coming in, which is why I think in the 70s or so, in Australia and then eventually in England, Singapore, Hong Kong, in other common law jurisdictions, this restriction on third-party funding has loosened. And it's developed to the stage where you have a dedicated third-party funding industry, again, in these various countries. And actually, India is not an exception, in the sense that there are a lot of very sophisticated local firms in India who bring funding to the table. So I was approached maybe about 6 months to a year ago by a domestic firm in India and they have very close links with these funders. And we were proposing to this third-party funder to bring a potential investment arbitration against the state. And the reason why the client was considering this was precisely because it wouldn't have to come out of their own pocket. We could use third-party funding and potentially get justice for this person, who had not been able to get justice otherwise, and for whom bringing a long and expensive investment arbitration might not have been a realistic option. So again, with the increasing sophistication of the modern world and of the increasing role in which financial instruments and financial options has changed the landscape, third-party funding very much is nowadays a very realistic option for all types of parties involved in all types of disputes.
Anthony, I just want to add on, there is one student who has posed a question. Should there be a cap on fees or cost of the arbitration? If you could just take it. It's on the chat, they've shared it. So if you could.
I think it's hard to say yes to that question, just because there are a lot of ways that you can control the costs of arbitration, and a lot of parties sometimes do put them into place in their arbitration agreement, or they have certain provisions in place within the institution to control costs. But it's hard to put a cap on for various reasons, but one being you run the risk that the tribunal at some point will just kind of stop putting in the work if they know that their work is not going to be compensated anymore. That's kind of a cynical way to look at it from my point, I admit. But if you put a cap on, a total cap saying no arbitration can ever go beyond this amount of fees, you do run that risk. SIAC keeps flexibility in their fee caps. So even if an amount in dispute is limited by the schedule of fees, if the complexity is of such high procedural or legal complexity, the SIAC has the discretion to go beyond that fee cap. And so I guess my final answer is you just need that flexibility, and I hate to put hard and fast rules or caps on anything. And you may disagree with me.
No, I mean, firstly, thanks very much, Dr. Garima, for stopping us. I think it's probably quite a good time in the webinar to perhaps open it up to a bit more of a Q&A session. I'm sure there are questions out there, and people don't want to just hear Chris and I rambling on for the next 20 minutes. To answer the question that was posed, as Chris was saying, it really depends on the complexity. Now, if a fee cap, if it's linked to the value of the dispute, makes some sense. As Chris was saying, in the SIAC, in the ICC, in lots of different institutional rules, the institution will fix the fees of the arbitrator subject to value in dispute. And again, there's some merit and some sense to that. But if you're talking about an overall total fee cap, I think that does raise some quite significant problems. As Dr. Anil mentioned at the start of this webinar, it's really important for the development of a country and for the legal system and for the arbitration practice in that country that you have rules in place that promote efficiency, and they promote best practices, generally speaking. Now let's say that there were, in Singapore, let's say, tomorrow they introduced a fee cap, an absolute fee cap for arbitrators, $1 million, let's say. That's a high amount, but let's say there's an absolute fee cap. If you as a lawyer know that the tribunal that you constitute in Singapore, let's say, will be subject to a $1 million fee cap, it's a little bit harder, I think, to say that Singapore is still at the top end of the spectrum, when it comes to favorable choices, because there'll be some arbitrators who simply don't want to arbitrate if they're subject to this ultimate fee cap. Now I think for $1 million, fine. Let's be honest, most people would say yes to it. But let's reduce the fee cap a lot to, let's say, $50,000 or $20,000. There's simply going to be a lot of arbitration lawyers and arbitrators who say, look, if we're dealing with a $400 million arbitration, how does it make sense that the arbitrators are restricted to $20,000, $50,000? So again, if it goes for that type of arbitration, where the level of complexity, the level of the amount in dispute is sufficiently high, I think it's very, very hard to justify a total fee cap, unless you put it at such an amount whereby you're literally talking about $1 million or more, perhaps.
Adding on to this, recently, so the fourth schedule of Indian Amendment Arbitration Act, it has provided a ceiling to arbitrator fees. So if it is it's a 30 lakh rupees, and if it's a sole arbitrator, it's 37 lakh INR. So and it has not yet been notified, but it has been challenged before Supreme Court that it cannot be a straight jacket formula. It has to vary. It has to vary on matter to matter and the transaction involved and complexity of the matter. So this has been the present scenario. So yes, Anthony.
So, Mr. Anuj, imagine if you're an arbitrator, and someone comes to you with a $100 million dispute, and it happens to be seated in India, and you're subject to this fee cap. Now, maybe you'll take the case nonetheless, but it does raise it raises these questions in your mind about, well, if the jurisdiction is putting in this absolute maximum fee cap, is it necessarily the best place to promote international arbitration? And I think it's a sort of a slippery slope to sort of be the first one to put in this sort of fee cap when you have competitors around the region who are not going to do so. And so a not very good example with professional football or soccer players. There have been a lot of calls for fee caps in the past, but they don't exist. And that's because if you start putting in a fee cap, the best players are just going to go elsewhere. It's as simple as that.
I think that's the reason the Indian arbitration disputes are shifting to Singapore SIAC.
There's no question that SIAC has seen a massive increase in arbitrations related to India, whether Indian parties are involved, either one or both parties being Indian parties. They have been number one. India has been number one in SIAC's user numbers for I don't even know how many years now, and there's something to be said, and I know our initial discussion was about the difference between institutional and ad hoc arbitration, but there's something to be said for the cost mechanisms and the curbs that SIAC has put in place to try to streamline and both time and cost efficiency. And I think you're right. I think that has had a big effect in drawing Indian parties to SIAC arbitration. Geographically, we're close. Culturally, there's quite a large Indian population here in Singapore. So maybe part of it has to do with cultural connections. Nobody really knows 100% for sure, but I would hazard to guess that the cost effects of having an institution like SIAC, administering your case has been a major draw. I mean, the second question on there about the effectiveness of MedArb, SIAC, I don't want to say, that MedArb and ArB-MedArb are different. They're kind of the same thing, but SIAC introduced a mechanism, again, to try to facilitate and promote mediation with the Singapore International Mediation Center to again try to bring the costs down. And what that process is that it's arbitration. You commence an arbitration. It's immediately stayed after the tribunal's constituted, and then moves to mediation. And if mediation is not successful, then the tribunal is already up and running, and they can move immediately back to arbitration. There has been quite there was a pretty significant interest right from the start of introducing that procedure. And I don't know off the top of my head the numbers, but it takes a few years for these things to start developing, because from their creation to companies putting them into their contracts and then disputes to arise, it takes a few years. So those numbers have started to grow. Whether they are effective is a question really for the parties, because mediation is always going to be a consensual resolution. So it's hard to say whether it's effective. It certainly encourages parties to try mediation, and I think there's benefits to encouraging parties to try mediation in most situations. I'm currently involved in a case. I'm looking at my Outlook right now, and mediator selection or prospective mediators just came in. We are using an ArbMed-Arb process right now, where we're in the middle of an arbitration, we're putting it on hold, and we're trying mediation. So it happens. I have no numbers for you to see how effective it is, though. But promoting mediation, like I said, is always a good thing in my view.
Chris, I have a lot of questions coming up from the students regarding, what kind of challenges do Indian students face when they are trying to avail internships or secure jobs in Singapore. So if you could just tell something about it.
I think this is something which is a very important thing to ask, actually.
Anthony, actually, you should answer this, because one of your partners is from India. So I would request you, if you could just tell these students as to, firstly, what kind of opportunities they would be having if they plan to, and what could be, the various challenges they would be facing. And I'm sure one of the partners is from India, so I'm sure she would have discussed something. So if you just, discuss, because they have these questions, and I think one of the important reasons to attend this is this.
No, absolutely. Thank you, Dr. Karim. And I actually want to get to this question as soon as possible. So I'll start off by saying this, that when Chris and myself are both not from Singapore. So once upon a time, Chris and I both applied to law firms in Singapore. We got in as trainee lawyers, as interns, as whatever else. And we spent many years rising through the ranks within our respective law firms to build the current careers that we have. We're still, we're nowhere close to being senior practitioners. We're both junior, mid-level practitioners. But we're both lucky enough to have gotten that first step to start working in Singapore. Now, how do you do it? I think there's, as with everything in life, a huge amount of luck involved. If we were to say it's because we're so brilliant, that's a complete and utter nonsense. The reality is that for any practitioner, for any student, whether from India or elsewhere, if you're looking to join international arbitration as an industry, I think one thing to really be very conscious of is that you're dealing with a global market. In other words, and this is something which we say to Singaporean students quite often, which is that, you might be quite good, you might be doing better than your peers, but are you doing better than the PhD guy from Oxford who just applied to me? Are you doing better than the girl from Harvard who just applied to me? How about this lady over here from I don't know, from MNLU Mumbai? You have all these really, really great CVs from all different people from all over the world. And the reality is that is your competition. It's not just the student in the chair next to you at your own local university. It's really a global market. Now bearing that in mind, how do you set yourself apart? And there are lots of examples of Indian students, Indian lawyers, who have gone on to make that transition from working domestically to working in international arbitration, either in India or elsewhere. At my former firm, Sherman and Sterling, there were at least 2, 3 associates who were very, very good. Freshfields, White and Case, all the top tier international firms have a lot of Indian lawyers in them. How do you make that transition? I think ultimately it comes down to making sure that you are seen to be dedicated to the practice of international arbitration and really demonstrating that this is what you want to do. And again, this applies, no matter what you do in life. Once you are showing the person who you're talking to that you want it more than anybody else, and that you've done your very best to show that to the person, that's impressive. It can be that you've taken arbitration as a module in university. It could be that you're actively reading up about developments from the Supreme Court. If I say something like Devas and Antrix or Balco or WASL, or if you know what these cases are straight away, then you're probably keeping up to date with developments in India at least. Are you keeping up to date with developments elsewhere? Are you publishing on academic topics? Do you genuinely think what we're talking about today is interesting, or are you just here because you have nothing else to do? It's all these sorts of questions which really set apart the people who really, really want it, and those who are just going through the motions. Now, again, frankly, when I started my career, I don't know about Chris, I didn't have this level of passion for what I'm doing that I do now. I wanted to be a public international law lawyer. I did the Jessup for my university, etc. I kind of segued my way into arbitration. But if I could do all of this again, I would have taken a lot more of a serious approach to saying, look, this is what I want to do, and this is what I'm going to do to get there. In other words, I would have structured I would have looked at people 5 years, 10 years ahead of me. Again, the successful Indian lawyers in these big firms, what were they doing? Did they start their practice at a very good firm in India? Did they do a master's somewhere? Did they go into academia? What did they do? And try and follow that path to some extent. It's a lot easier than sort of reinventing the wheel each time.
Anthony, I again have another question. What about online internships? How much of it, hold the weightage?
Sure.
Because currently, for the past 2.5 years, all of us are working online. So if these students, they would want to approach you for online internships and all, just for for information, then how far it would be, a valid addition to their CVs.
I'll say this. This is purely for me personally, and Chris might have a different opinion. Anuj might have a different opinion. I'm generally quite skeptical personally of doing online internships as opposed to in-person internships and just starting your career. I think when you're physically in the office with your colleagues, there's so many small things that you will learn on the ground just by being there in the heat of battle. And these things you don't quite get them if you're doing an internship virtually. I've had virtual interns in the past, and I'm not adverse to having more virtual interns. I have a paralegal in my team who is based in New York, and we're 12 hours. The time difference is 12 hours, and it's tough. But we find ways to make the working relationship profitable and successful. And I've seen a lot of applications from law students in various places, including India, and they have a lot of virtual internships. So my personal feeling is that if you have an opportunity of working in the office with a firm in your vicinity, that's where you'll get the real experience, the really, really true law firm experience. But if you can, try for an internship overseas as well, a virtual internship. It might end up better for you than it was for me with my past interns.
I guess I would echo, going back to the first question, I would echo most of what Anthony said about finding a way to differentiate yourself. We receive applications on a daily basis, pretty much. especially in the last few years with the way the market has shifted. A lot of people from all over the world are looking to work in Singapore. I think Anthony and I were very lucky to get into Singapore right at the kind of the start of the kind of exponential growth of arbitration in Singapore, and we really were lucky to get in there. But now it's extremely difficult. You have generally international arbitration teams are run quite leanly. You don't have huge litigation teams like you would in some kind of just general litigation departments. You generally have only a few people working on cases. They're often cross-office. So I work a lot with my colleagues in Europe or the United States. So where we have a global network, we leverage that. And so, we can work essentially 24 hours. But what that means is that we can keep our teams quite lean in different locations and use the resources we have all around the world to our benefit. So what I want to say that to say the competition is very strong. So like Anthony said, you have to differentiate yourself. The first thing we will look at, and this is not even, I don't care what your GPA is, the first thing I will look at is whether you have dedicated or shown an interest in international arbitration that comes out clearly from your CV. If you haven't, you're not even going to get through the first step of the review. So, have you done a moot? Have you done a diploma or done a specific course that's offered in your university? Have you done an internship where you've done in arbitration? Focus on that, highlight that, and make it very clear that this is something that you see as a long-term endeavor. The last thing that we want is someone to come in and just see an international arbitration team as just a 2-month placement that they'll never turn and do it again. And especially with the number of applications we get, we have a lot of people that we don't want to turn away people that really have that dedicated focus. So yeah, I think you really need to figure out how to differentiate yourself and know how to speak about the industry. Like Anthony said, he can rattle off name some cases from India that you're probably going to get asked about if you have an interview, because they are known globally. These cases. So read things like the Global Arbitration Review. Read the headlines, because you have to pay to actually have a full subscription. But just to keep abreast of what, and I'm not sure if MNLU has a subscription to Global Arbitration Review or not. But if you do, read it. Read the various arbitration blogs, because these people that are involved in arbitration, people that work in arbitration, are kind of arbitration nerds. And we like talking about this stuff, and we like to have debates. Anthony and I see each other very frequently over lunch and often debate really detailed pieces of arbitration procedure that probably nobody else would be interested in. But
we're actually quite lame. We're quite boring.
We are very lame. But that's the type of person that these international arbitration teams are looking for. We look for arbitration nerds, because it's a very niche field, and it's often you need those people to kind of float ideas off of that'll appreciate it. As far as hybrid internships is concerned, I kind of have a similar view as Anthony. We have done it in the past, during COVID, especially when people just could not travel. I would hesitate to say that it's a very good experience, because similarly to Anthony, a lot of an internship is making the connections, making the personal connections, and really sitting down and being able to talk to me, in my office when I see a draft, which is much more difficult. It can happen online. I'm not saying it can't, but it's much more difficult to do that virtually and to get that FaceTime and get that benefit. Similarly, we've done it in the past, but I don't know, especially these days as things are starting to open up. Hopefully, it's not required anymore.
I'll just add one final point about internships and global competition, because I don't want to dispirit everybody on this call saying, oh, it's so hard to get these internships. One thing about the global nature of arbitration is that, arbitration in Singapore is pretty similar to arbitration in London, which is pretty similar to arbitration in France, which is pretty similar to arbitration in Venezuela, in Frankfurt, and everywhere else. So the question that we were asked is, well, how would I, an Indian student, get into arbitration in Singapore? The answer I would say is, why are you looking at Singapore necessarily? There are lots of very, very good Indian students and lawyers who now practice arbitration from different jurisdictions. So, for example, at my former firm, I had a junior associate who joined us, and I was looking at his CV, and he had done internships in Korea, for example. And I was like, bro, how come you went to law school in India? What are you doing? What were you doing in Korea? He's like, oh, I actually really like K-pop. I was like, fair enough. Fair enough, right? Like, why should you be restricted just to common law jurisdictions? Why should you be restricted to the places where everyone goes to? So, if you genuinely want to do arbitration, and if there are other places where perhaps, there aren't as many people applying to, why don't you consider those jurisdictions? If you happen to speak a foreign language, if you have some sort of interest in, I don't know, if you can speak a little bit of Mandarin, being an Indian lawyer in Hong Kong would be extremely useful. If you're genuinely interested in, I don't know, football, let's say, and you like watching La Liga, maybe try and do an internship with a Spanish firm. You never know. International arbitration really is international. And there's no reasons why you should just restrict yourselves just to looking at Singapore because it's nearby. That there are lots and lots of markets where if you put your mind to it, you can find those opportunities. And again, it goes back to how much do you want it? Like, do you want to work in arbitration badly enough to go and work in, South Africa for 2 years, to go and work in Brazil, to do an internship in I don't know, Kazakhstan? Because if you really want it that much, then you'll find a way to make it. And it's the people who really want it badly enough who will be talking in 5-10 years time, saying, you know what, when I was a student at MNLU in 2022, I didn't know what to do, but I found a way to make it work, and that's how I started my career in arbitration.
And I would just add to the geographical flexibility, that you should also not just consider focusing on law firms. International arbitration practices at private law firms are great, but as I said before, they're usually very small teams, and there's limited numbers of teams out there. Anthony and I both got our starts working for an arbitrator. We worked for an independent arbitrators chambers where we saw a lot of cases, more cases than you would see as a practitioner in a law firm. I worked at the institution, SIC, where I administered 250 over cases during my time there. So look for independent arbitrators in your area or outside your area that might benefit from having some assistance. Look at institutions and international internships at institutions. I know the ICC, SIAC, KLRCA, or now the AIAC in Kuala Lumpur, they have formal internship programs. Look at these places, these kind of non-traditional places. Don't restrict yourself. The only way that I think Anthony and I got to where we are now is because we were open to working in a non-traditional, to start our careers in a non-traditional way. And that is, international arbitration is a non-traditional practice. So just keep an open mind is my main piece of advice, I guess.
Thank you so much for clearing out their doubts. I would like to, thank you for this interactive and insightful webinar. And I'm sure the students would have made the most out of it. And I personally want to thank three of you for putting this together and partnering with MNLU. I hope this is the, not the only first one. It shouldn't be the last one. And I hope we create and build this foundation. Now I would request Dr. Anand Roth, Head of the Department, PG, and Chairperson of Center for Postgraduate, for delivering vote of thanks.
Yeah, am I audible?
Yes, sir.
Yes.
Dr. Garima, you have partly taken care of my job of thanking, but seat and place of arbitration, that was the point of discussion from where Anuj picked it up, and it was no looking back. We have been seeing, we have got used to virtual sessions, and virtual sessions becomes sometimes monotonous because of course the mood, but this was an exception, and I guess even the students or the participants would accept to this. It was really an analysis driven session, and just kept us thinking, and very interestingly the points were brought out and the responses were also relevant. So starting from seat and place of arbitration, we discussed practices that honors the integrity of arbitration, especially appointment of arbitrator, how important role it plays. We went on to discuss ad hoc and institutional arbitration, the difference between them or the similarities between them, how we are supposed to strategize and manage disputes within an arbitration. We went on to discuss evils of multiple hearings and the high cost of arbitration involved in it. By the end of the session, we also discussed about the resource persons had their opinions besides the points that I just now listed out on third-party funding and the legality, the morality, the ethics aspect of it, and the practicality aspects of it. So the problems that the honorable speakers listed out today was the cases are not properly managed. Multiple hearings are taking place. Arbitration has become expensive. It is complex. The laws are complex. Sometimes the laws are not comprehensive enough, as in the beginning Anuj also explained us. And yeah, so if you look at these problems, aren't these the problems for which we had brought in arbitration? I always say this, that the problems, the evils which had to be taken care of by the arbitration is itself being reciprocated by the arbitration now. So yes, it was very interesting discussion, and by the end of the session, the guidance that has gone from all the resource persons, this is the right time where the students should have got that, with their past experiences. Yes, it might have encouraged few, it might have tested them. It was a reality testing also, the experiences that that was shared by the resource persons. And I hope that the reason for which, and the significant stakeholders of this program, that is the students, they must have got benefited out of it, because this entire exercise is for them. So I want to thank Anuj Singh, Advocate, Supreme Court of India, and also Standing Counsel for various state government undertakings, Anthony Nichols, Counsel, Fort Law LLC, and Christopher Bloch, Senior Associate, Squire Patton Boggs, Singapore, for delivering this very intriguing session to us. It was attended. I can see some of the non-teaching staff also was attending besides the students and teaching staff. I hope that this collaboration and for which I want to thank Dr. Garima Pal and Anuj Singh. Both of they have been communicating and coordinating with this. So all the credit of organizing this goes to them. I want to thank Honorable Vice Chancellor, Professor Dr. Dilip Uke, Registrar, Professor Dr. Anil Variath, Dr. Harita Bangali, Director, Center for Advanced Legal Studies, Training and Research, for giving us this platform, for helping us out in arranging this program. And most importantly, I want to thank the students who have attended this program in large numbers. These are my students, most of them, my master's, my PG student, and I hope that this session would have really benefited them. So on that note, I again sincerely hope that we would be seeing 3 of you, but next time we would like to see you physically. At our campus. I guess Registrar Sir has to share something.
No, just you said we want to see physically, then I was so delighted, then I switched on my video. That's all.
We would love to host you here.
Yeah.
Chris, you were here only, no, in India, I think. So next time, please let us know. We would love to meet you in person.
Absolutely.
Thank you so much. In that note, I would like to end the whole webinar. Thank you so much, all of you, for taking out your precious time. It's been a great learning platform for all of us. Thank you again.
Thank you so much. Thank you so much.
Everyone.
And Anthony is on his holiday, so I'm most thankful to Anthony that he took 2 hours time out of his holiday. Thank you so much.
It's a pleasure. It's a pleasure.
Thank you
so much, everyone.
It was an amazing experience. Thank you so much.
Hello. Yes, madam.